whether the defendant can be allowed to claim equities in his favor after having knowledge of the plaintiff's prior use trademark. This is the issue of today's video. Suppose a plaintiff files a suit in respect of infringement of the trademark and passing of action against the defendant. The defendant appears, takes the defense of long use of the trademark being used by the defendant. However, he is well within the knowledge of the prior use of the trademark, whether that defense of the long use can be considered or not. The answer is no, not at all. It cannot be considered. For this, let me discuss some judgments. First judgment is in the case of J.R. Parkinson and Co. Limited LD 63 RPC 171 at page number 181. Now I am quoting the words of Honorable Judge Romer. In my judgment, the circumstances which attend the adoption of a mark in the first instance are of considerable importance when one comes to consider whether the use of that trademark has or has not been an honest user. If the user in its inception was tainted, it would be difficult in most cases to purify it subsequently. In other words, the equitable relief will be afforded only to that party who is not guilty of a fraud or whose conduct shows that there had been on his part an honest concurrent user of the mark in question. If a party, for no apparent or a valid reason, adopts with or without modifications a mark belonging to other, whether registered or not, it would be difficult for that party to avoid an order of injunction, because the court may rightly assume that such adoption for the mark by the party was not an honest one. The court would be justified in concluding that the defendant in such an action wanted to catch the plaintiff's name and reputation, and that was the sole primary and the real motive of the defendant adopting such a mark. Even if in such a case there may be an inordinate delay on the part of the plaintiff in bringing a suit for injunction, the application of the plaintiff cannot be dismissed on the ground that the defendant has been using the mark for a number of years. This is the one judgment. Now, second one is I am relying upon one book written by Honorable Mr. Harry D. Names. The name of the book is The Law of Unfair Competition and Trademarks, 14th edition, volume 2 at page number 1282. It was observed that, now I am quoting the words, whether infringement is deliberate and willful and the defendant acts fraudulently with knowledge that he is violating plaintiff's right, essential element of estoppels are lacking, and in such a case the protection of the plaintiff's rights by injunctive relief is never properly denied. Third one is Hindustan Pencils Private Limited versus India Stationery Products Company AIR 1990 Delhi 19 para number 25 onwards. There is very good discussion in this regard as far as from para number 25 onwards in this judgment, and that is why it is to cut short my video. I am not reading the entire judgments from para number 25. The fourth judgment is Superflow versus Sandhyamani 2015 SCC Online Delhi 14403 para number 39. I am reading para number 39 now. If the entire object of the trademark law is examined, it is obvious that the date of adoption of the mark of a party is the relevant date. In case on the date of adoption it was found that he was aware about the mark of the rightful owner, the using of the mark and filing of an application in the trademarks office is fraudulent. As dishonesty starts from the beginning itself, the subsequent user is to be considered as tainted. As the party was aware that the mark actually belongs to other party and he is not the owner of the same. He is not the owner of the same, and it is totally immaterial if the registration is objected of a copied mark or it is totally immaterial if the registration is objected of a copied mark of a party who adopted and used the mark in earlier point of time. There is no much difference if the registration is obtained on the basis of non-filing of opposition. The party who has stolen the mark cannot claim the benefit of concurrent user because the governing principle of concurrent user lies on account of honesty. So the answer is, if the defendant takes the defense of the long use of the trademark in that suit, but that use of the defendant is not an honest, then concurrent use of the particular mark cannot be considered and injunction in favor of the plaintiff has to be granted. Friends, I hope you like this video. Friends, if you like this video, please don't forget to subscribe my channel, and please don't forget to make necessary comments in this regard. Thank you very much.